Ms. Farah, from our last meeting, we have filed the necessary cost papers, such as our rate and our statement of claim.
Okay.
And both parties have now closed their pleadings.
And what comes next?
Next, the court will set a date for us to do what we call a pre-trial case management, during which the court will give us further directions on what to do next and set a date for a trial.
Oh, that sounds so long. Can you just tell me when will I get this compensation?
To be honest, Ms. Farah, it may vary. It may take months or 2 years. But from our side, we cannot promise you anything, unfortunately.
Years? What do you mean years? I have already suffered so much and I don't know how long I can survive with all the money that I have left. I am paralyzed, I lost my job, and I cannot do my basic daily function without any helps from others, and hence why I have to hire a helper. And you know how much it will cost me. Moreover, I have my children. I have 4 young children which I have to take care of as a young single mother. And you're telling me I have to wait years for me to get compensated? That is insane.
Well, Ms. Farah, we totally understand your frustration, but we just want to assure you that this is not the dead end.
Okay.
There is this application called interim payment, where you can actually get early payment for some proportion of the damages that you have suffered.
Okay. Can you tell me what are the procedures?
I'm glad you asked. Interim payment refers to a payment by the defendant of a part of the damages, debt, or some other sum excluding cost to the plaintiff before the final determination of the case. Hence, an interim payment does not represent a conclusive finding on liability or quantum, but instead functions as an advance on the sum that the plaintiff is likely to recover from the defendant at the end of the trial. As uttered by the Court of Appeal in the case of David Sheila, the rationale behind this mechanism is to alleviate the plaintiff's hardship during the pendency of the proceedings by enabling the court to award, at an earlier stage, a portion of the sum likely to be due to the plaintiff upon the final determination of the suit. Historically speaking, Order 22A came into force on the 1st of August 1993, as was noted in the case of David Sheila. Prior to that, Lord Scarman, in the case of Jamil bin Harun and Yang Kamsia, found that Malaysia did not have a provision pertaining to interim payment and encouraged Parliament to create such law. Interestingly, only about 10 years later, Parliament finally introduced Order 22A, and remarkably, from 32 years ago until today, there had been no amendments made to Order 22A. Today, interim payment is most commonly granted in personal injury cases, for example, where a plaintiff suffers serious injuries and urgently needs money for medical treatment, physiotherapy, rehabilitation, or loss of income. It may also apply in fatal accident claims where dependents need financial support pending trial. In addition, can extend to contractual, construction, and other monetary disputes. However, Order 22A does not apply to claims seeking only injunctive or declaratory relief, as such claims do not involve monetary compensation.
Thank you, Ms. Ogin. Like any other areas of law, interim payment also has its own governing principles. For example, what must be proven in a claim under Order 22A, and what is the standard of proof that must be satisfied? On this point, we shall first address what must be proven as grounds to grant an interim order. This is laid out in Order 22A, Rule 3, Sub 1 of the Rules of Court, which states 3 grounds, namely A. That the defendants have admitted liability for the plaintiff's damages, or B. That the plaintiff has obtained judgment against the defendants for damages to be assessed, or C. That if the action proceeded to trial, the plaintiff would obtain judgment for substantial damages against the defendant. Notably, as shown above, the Court of Appeal in Joshua Engineering ruled that Rule 3 Sub C allows interim payment of damages even though liability is still in question. However, it appears from a plain reading of Rule 3 Sub 1 Sub C that the court must first be satisfied that the plaintiff has a strong likelihood of success. However, this was clarified in the recent case of Seat Advisor Sendirian Berhad and Perbadanan Stadium Malaysia, whereby in balancing the parties' interests in an application for interim payment, the court only required reasonable certainty rather than absolute certainty that the proposed interim payment amount was likely to be the minimum sum the plaintiff could recover from the defendant if the action proceeded to trial. If the plaintiff is able to satisfy any one of the requirements above, the court, by virtue of Order 22A, Rule 3.1, may order the defendant to make an interim payment to the plaintiff. As regards the standard of proof, the courts have answered this question quite synchronously, such that the standard of proof required in an application for interim payment is on the balance of probabilities and not beyond reasonable doubt. However, in David Chelia, the Court of Appeal held that there is no necessity for the plaintiff to show that he would suffer prejudice if he did not obtain an interim payment. Neither must he show that a particular sum is required to cover a need. In rewarding an interim payment, therefore, the court is not concerned with how the money is to be spent.
However, it must be noted that the balance of probabilities to be satisfied is at the upper end of the scale, the burden being a high one. The Court of Appeal in Gibbons and Wall explained that this is because litigation of its nature involves no certainties. A plaintiff with what may appear on paper to be a strong case may find it fail at trial. If he does, then he will have to repay the whole or, to the extent that he feels, part of the interim payment. The problem arises where the plaintiff may have spent the interim monies and hence it may become difficult for defendant to recover the monies should the plaintiff ultimately fail at trial. Now you may wonder, in what situation may interim payment not be granted? While there are grounds to allow an interim payment, there are also grounds to reject an interim payment, and this is found under Rule 3 Sub 2 where interim payment would not be granted where the defendant is not a person falling within one of these categories. First, a person who is insured in respect of the plaintiff's claim. Second, the public authority. And third, a person whose means and resources are such to as enable him to make the interim payment. Further, Rule 11 provides that no interim payment against the government, and the government here is defined in Order 1 Rule 4 as meaning the federal government or the state government or both.
Now, you must be wondering, how much could I get from an interim payment and how is it being calculated? How do I receive this payment? At this juncture, I would like to emphasize that an interim payment order is not confined to merely damages, but any other sums excluding costs by virtue of Rule 4. This includes an order for various types of accounts, a claim in relation to the possession and use of land, and a claim on a quantum merit basis. Now, moving on to perhaps a rather more exciting part, but nonetheless important, how much could a plaintiff get from an interim payment and how is it calculated and how does the plaintiff receive this payment? As mentioned earlier, the court is only keen in granting a reasonable proportion of the damages likely to be recovered. What then amounts to a reasonable proportion? The court in Media House Sendirian Berhad and Koh Kim Swan ruled that this is entirely reliant on the court's discretion of what amount it thinks just, and of course, after taking into account any set of cross-claims or counter-claims which the defendant might be entitled to rely on. Now, moving on to the manner of payment, this is found under Rule 5. As a general rule, the sum is to be paid directly to the plaintiff unless the court orders that it be paid into court. Where payment is made into court, the plaintiff may apply for the whole or any part of the sum to be paid out as the court deems fit. Any application to withdraw money paid into court must be served on the defendant. The court also retains discretion as to the mode of payment, which may be ordered either as a lump sum or by installments. Additionally, where the interim payment relates to the defendant's use and occupation of plaintiff's land, the court may order periodic payments pending the final determination of the action.
Okay, so now that we have talked about the governing principles of Order 22A, let's now talk about how we can apply for an interim payment. So Rule 2 sets out the manner of making an application for interim payment, and under Rule 2.1, the writ must first have been served on the defendant and the time for acknowledging service must have expired. So pursuant to Rule 2.2, the plaintiff is required to file a notice of application in Form 33 supported by an affidavit, and although such an application may alternatively be incorporated into an application for summary judgment under Order 14. So next, under Rule 2.3, the supporting affidavit must verify the amount of damages, debt, or other sum claimed and set out the grounds for the application. It must also exhibit any documentary evidence relied upon by the plaintiff. And in cases involving claims arising from a fatal accident under Part 3 of the Civil Law Act 1956, the affidavit must further provide full particulars of the person on whose behalf the action is brought, as well as the nature of the claim for damages. So finally, Rule 4 requires that the notice of application and the supporting affidavit be served on the defendant not less than 14 clear days before the written date, which refers to the date of trial or hearing set by the court. The hearing will be then conducted inter partes, meaning both parties are present and can submit their respective arguments.
So now explaining the defendant's recourse. What can the defendant do to oppose the application? Now, of course, the defendant would not be left without any recourse to defend itself against an interim payment application by the plaintiff. For example, a defendant may contest the interim payment application by way of technical objection or procedural non-compliance, such as where the claim is for personal injuries but he is not person insured in respect of the plaintiff's claim, or that he lacks the means and resources to make such payment. Further, as already mentioned under Order 22A Rule 2 Sub 3, the affidavit must verify the amount claimed, state the grounds of the application, and attach supporting documents. Hence, if the affidavit is defective or if material facts are omitted, the defendant may object the application. Secondly, the defendant may challenge the application on its merits by demonstrating that there is a serious doubt as to whether the plaintiff will recover any sum at trial. In this regard, the decision in Josu Engineering Construction Sdn Bhd and PSR Bina Sdn Bhd is instructive, where the court said that the interim payment is only appropriate when the likely damages are significant and not merely nominal. Another important case is the case Tiu Sai Hong and Pantai Medical Centre Sdn Bhd, where interim payment was granted to help the plaintiff pay for medical expenses. So the court emphasised that the plaintiff must show both a strong case and the likelihood of receiving substantial damages. On the other hand, the defendant may also argue that the amount claimed is excessive and would unfairly prejudice the defendant. This is because interim payments should only be a reasonable proportion of the likely damages and not an overpayment. Finally, the defendant may also dispute the quantum sought by raising defences such as contributory negligence, set-off, cross-claims, or counter-claims.
Speaking of the defendant, the question arises, if he makes the interim payment, wouldn't that amount to admitting liability? This concern is addressed under Rule 4, which provides that the court may order an interim payment without affecting the parties' positions regarding the nature or character of the sum claimed by the plaintiff. Furthermore, the fact that an interim payment order has been made is not to be pleaded, unless the defendant consents or the court directs otherwise. No reference to the making of any interim payment shall be disclosed at the trial or hearing of any issue relating to liability or damages until all such issues have been finally determined. Hence, the defendant's legal stance is protected in the sense that the making of an interim payment does not constitute an admission of liability nor prejudice his defense in these proceedings. Now that we have seen some of the weaknesses in Malaysia's position, let us turn to Singapore, which has the stronger approach. At a basic level, both jurisdictions serve the same purpose. Interim payment allows money to be paid before trial or hearing on account of what the defendant may ultimately have to pay, excluding costs. Now, with that being said, Malaysia is not weaker in every respect. It is more detailed on matters such as forms, timing, and procedure. This makes the process easier to follow in practice. However, the same level of detail may also draw parties into procedural technicalities, causing them to focus too much on compliance rather than the real substances of the application. Singapore's rule, by contrast, is shorter, more compact, and more streamlined. So, while Malaysia is stronger in procedural detail, Singapore is stronger overall. Now, how is it stronger? First, on the conditions to be stated by the plaintiff, Singapore is in the stronger position. Under Order 13, Rule 8, Subsection 3, the claimant's affidavit must state the amount of the claim, whether liability has been admitted or established, and if not, why there is a strong case, and also why interim payment is needed at that stage. This is clearer and more focused because it makes the claimant address the amount, the merits, and the need for early payment. By contrast, under Order 22A Rule 2 Subsection 3, the Malaysian affidavit must verify the amount claimed, state the grounds, and exhibit the supporting documents with further particulars required in certain cases. Malaysia is stricter on verification and documents, but Singapore is better because it frames the claimant's duties more directly around the real issues before the court.
Second, on the court's approach, Malaysia still follows a stricter threshold model. Under 22A Rule 3, the plaintiff must first satisfy fixed gateways such as admitted liability, judgment for damages to be assessed, or prove that substantial damages would be obtained at trial. The old Singapore position was similar. In the case of American International Assurance Company Limited and Wong Chern Yao and others, the court applied a two-stage test. However, Singapore moved away from that model in the case of Ng Zi Liang and Boon Gia Min. The court held that the old two-stage test no longer applies under the rules of Court 2021. Instead, the court now undertakes a holistic assessment under Order 13 Rule 8 Sub 3 and 4 and guided by fairness. This makes Singapore better because it is no longer confined by rigid threshold categories and can focus on the substance of the case. Malaysia should move away from an overly rigid threshold model and allow a broader fairness-based assessment. A more flexible approach would give the court greater room to consider the case as a whole and reduce over-reliance on technical gateways. Malaysia should require the plaintiff to state in the affidavit why interim payment is needed at that stage of proceedings. This would make the application more focused and assist the court in assessing not only the amount claimed, but also whether early payment is justified in the circumstances.
Third, on the type of claims covered, Singapore is again better. Malaysia still separates claims for damages under Rule 3 and claims for sums other than damages under Rule 4. Singapore removes that distinction and uses one general rule covering any amount the defendant may be liable to pay. As recognized in Ng Zi Liang, this is a welcome simplification. It avoids unnecessary arguments about classification and keeps the focus on the substance of the application rather than procedural divisions. Hence, we think that Malaysia should simplify Order 22A by removing the distinction between claims for damages and claims for other sums.
Fourth, on who may initiate interim payment, Singapore also adopts the broader approach. In Malaysia, under Order 22A Rule 21, only the plaintiff may apply. However, in Singapore, under Order 13 Rule 8.2 and 3, the claimant may apply, but the defendant may also make an interim payment voluntarily without waiting for a court order. This is better because it gives both parties more flexibility. The claimant may receive payment earlier without the cost and delay of a formal application, while the defendant may reduce legal costs, limit the accrual of interest, and act reasonably at an early stage. Malaysia should expressly require the court to consider the defendant's ability to pay in all cases, not just in the limited context of personal injury claims. This would create a more balanced assessment and ensure fairness to both sides.
Fifth, on fairness and the defendant's position, Singapore is also stronger. Under Order 13 Rule 8 Sub 4, the court expressly considers contributory negligence, set-off, or counterclaim, and importantly, the defendant's ability to make the interim payment. In Malaysia, this appears more narrowly under Order 22A Rule 3 Sub 2, where in personal injury cases, no order may be made unless the defendant is insured, is a public authority, or has sufficient means and resources. Singapore's approach is better because inability to pay is not treated as an automatic bar, but as a part of the overall fairness assessment. So this allows the court to weigh hardship on both sides and makes the process more balanced.
Sixth, on repayment and safeguards, Singapore provides greater certainty. Under Order 22A Rule 6, the Malaysian court may make such orders as is just, including repayment and variation. Under Order 13 Rule 8 Sub 9, however, if the final judgment is less than the interim payment already made, the court must order repayment of the excess. Singapore is therefore better because repayment is mandatory rather than discretionary, giving clearer protection to the defendant. Malaysia should introduce a jurisdictional safeguard so that an interim payment made under protest does not reduce the value of the claim for jurisdictional purposes. Singapore also has an additional jurisdictional safeguard under Order 13 Rule 8 Sub 11, where payment is made under protest, the payment does not reduce the value of the claim for jurisdictional purposes. Malaysia has no equivalent rule. This makes Singapore better because it prevents interim payment from being used tactically to force a case into a lower court and protects the proper forum of the dispute. Therefore, Malaysia should provide clearer repayment consequences where the final judgment is lower than the interim payment already made.
Lastly, Singapore is also in a stronger position in relation to claims against the government. In Malaysia, Order 22 Capital A Rule 11 expressly provides that no interim payment order may be made against the government. Singapore, however, has no equivalent blanket exclusion under the Order 13 Rule 8. This makes Singapore's position stronger because the government is not automatically shielded from interim payment where liability is clear. So, Malaysia should reconsider Order 22 Capital A Rule 11, which prevents interim payment orders from being made against the government. Removing this blanket prohibition would place the government on the same footing as the other litigants and better uphold the principle of equality before the law where liability is already clear. To summarize, the introduction of Order 22 Capital A ROC 2012 was clearly a positive development for Malaysia as it provides more accessible process for interim payment. At the same time, unfortunately, when compared with Singapore, Malaysia still appears more rigid and technical. Singapore's approach is stronger because it is more flexible, more streamlined, and gives the court a broader room to assess fairness in each case. That said, Malaysia should not adopt Singapore's position entirely. Malaysia's detailed procedure is still considered as one of its strengths, so the better approach is of course selective reform. Malaysia should keep its procedural clarity but adopt the stronger features of Singapore's model such as simpler structure, broader judicial flexibility, and clearer safeguards.
Wow, that is really reassuring.
Yep, like we said, it is not the dead end, Ms. Farah.
Yep. But Ms. Farah, we must remember, and we want to remind you on this, that interim payment is meant to balance between two interests. On one hand, it protects the plaintiff from hardship, and also on the other hand, it protects the defendant from paying too much too early.
So, shall we proceed with this, Ms. Farah?
Very well, let's just file this application for interim payment and hopefully I will get a reasonable proportion out of this.